Prof, Senior Counsel did explain the thin line between mediation and arbitration. And here in mediation, he said, is assistance of the parties to negotiate and come up with mutually beneficial outcomes. And when they draw these cases from courts of law and opt for the alternative dispute resolution mechanism, then when they come up with this agreement through the third party or via the third party, how binding is this in terms, in the context of our laws or the rule of law in the country?
Very binding. First of all, I wanted to say something about the applicability of AJS to criminal cases, but maybe I can do that after I answer the question. I wanted to clarify something that Jerry has said in this regard. But let me say this: when it comes to arbitration and mediation, usually it depends on what context it's being done. For mediation, if it's part of the court annex mediation, then what happens is they have been sent out by a judicial officer for the court annex mediation, and the settlement agreement is brought to court, and then it's adopted as a judgment of the court. Okay, but in most of the times, in fact, what we are trying to encourage in this way is what we're calling private mediations. Private mediation agreements is where you don't even have to go to court. You have a dispute between two parties. You just go to a private mediator. They facilitate the mediation. You come up with your own agreement, and most of the time, you just enforce it. You don't need to go to court. You don't need to fight it in court. It just, it's self-executing. And this is true also for arbitration agreements. A lot of arbitration agreements don't see the light of day in court. Because you have a dispute, you have an arbitration clause in the dispute, you go to an arbitrator like Jerry, the arbitrator decides the case, you go ahead and execute what the arbitrator has agreed. You don't even have to go to court. Usually, it is the rare case that finds its way to court where one of the parties becomes intransigent. And then the court then now adopts it as an order of the court, and it can be executed as an order of the court. So to that extent, then it's very binding. But it's important to say that a majority of these agreements really are never even brought to court, because parties go, they resolve their disputes, and that's it. That's the end of the matter. So I would venture to say about 90% of them don't even come to court at all. This is why when we did the Justice Needs Survey, we found that 79% of disputes are resolved outside the court system, and we don't even get to know about them in court. It's only 21% of them that actually find their way to court. And then we start parceling them out to mediation, to arbitration, to AJS, and so forth. And that's a really good thing, because you can imagine if we have a backlog. The last State of the Judiciary, State of the Administration of Justice report showed us we have about 678,000 cases that are backlogged. That means they are more than 360 days old. So if we have 678,000 cases as backlog, out of only 21% of disputes that find their way into court, you can imagine how much backlog we would have if all 100% of them actually came into court. So in fact, what we're encouraging parties is to continue resolving their disputes without necessarily finding their way to court, so that even the 21% that are in court, we are finding that many of them do not even belong in court. They could be more optimally be resolved outside court through arbitration, through mediation, through alternative justice systems, and so forth.
Okay. But Prof, what then does that communicate? What are the signals that then, as a senior judge, for that matter, may I say, then, or the senior counsel, or in Nigeria, a chartered arbitrator, what are the signals then, or the smoke you get out of it? Is it because of its easiness? Is it because of the time that it cuts in terms of handling that process? And does it also then give us the signal from the other end of the court, which are the courts of law, the justice system in the country, of complexity, time-consuming, language barrier, advocates speaking for you, you're not in tandem with the communication process? What does it say about our justice system in terms of the message that we're getting out of that process?
Well, it just says that our justice system is functioning as it should be, in my view. That's what it says. It just says that we are empowering the justice seeker. We're giving more agency to the justice seeker by opening more doors, so that the justice seeker, an empowered justice seeker, then can decide, I think my case will be more optimally be resolved through mediation. I think my case will be more optimally resolved through arbitration. I think my case will be more optimally resolved through alternative justice system. Such an empowered justice seeker then is a better citizen, I think, and also enables our justice system to really move the way it should. Then the cases that really should be in court, and that's not only necessarily because of the complexity of the matter. Mediation resolves cases that are very, very complex. Arbitration resolves cases that are very, very complex. The case that we just had from Kajiado that took 32 years was a very, very complex land case. But they were able to resolve it within the alternative justice system. So it's not so much about the complexity of it. It's really about the kinds of rights that are involved, the polycentricity of the issues, and so forth. So that's really what comes into play. So all we are saying is that there are some kinds of cases which are more optimally resolved in other fora for dispute resolution, and you get more substantive justice there, while there are some kinds of cases that really must end up in court, because that's basically where Kenyans decided this is the default mechanism. The default mechanism that Kenyans decided is the judiciary. And that is why what we keep saying is that the theory we use is the agency theory. The agency theory is empowering the justice seeker to have as much agency as they can to choose the forum. If the justice seeker chooses and insists on ending up in court, then so will it be, because that is the default that Kenyans have chosen. But we are trying to dissuade people from this narrative that justice that is given in our formal justice system is necessarily better justice. In fact, most of the time, it is not better justice. Most of the time, it's technical justice.
Okay, so it's a supplementary to our judicial system, more or less. That's what you're communicating.